Good afternoon. Welcome to the September Benefits Lunch Break webinar series. I'm Frank Barradin, and I'll be handling the presentation for this month. And fortunately for me, there wasn't anything that was earth-shattering that was released in the last few days, so I didn't have to scramble to put something like that together. But we do have a few things that have occurred in the last few months, and some reminders of things that you want to be thinking about as you get to year end for basically your retirement plans. The first thing I want to point out is that our next webinar will be on November 20th, and it says topics to be determined, but I'm pretty sure that we will do our annual Ask a Benefits Lawyer presentation. So sometime between now and November 20th, if you have any questions that are things that you'd like us to address in that webinar, submit them, and we will certainly try our best to address them. If they're super complicated, long, detailed questions, probably not something that we can really address in that scenario. But if there's things you're thinking about or something that you're like, I've never really seen this addressed, and it's something that I was thinking about and would like to hear why we can or can't do that. Those are the kinds of things that we're always happy to address there. So look forward to that one on November 20th at noon, and that will be our next webinar. So to get started on what you need to be thinking about as 2024 comes to an end. So the first thing that I still see people forgetting about is that we've had a change in the law basically 2 years ago on the safe harbor deadlines. And so if you want to use the 3% safe harbor non-elective contribution to pass your ADP and ACP test for a 401k plan, for 2024, you have until December 1, 2024 to make that election. And that's really whether you sent out a preliminary notice at the beginning of the year or not. And you really have until December 31, 2025 to still make that election if you were to use the 4% safe harbor. So I saw some clients who could have benefited from the 4% safe harbor, making it by the end of this year for 2023. And even though it's not too late to still do that, they had already done refunds. They processed refunds to their highly compensated employees for 2023. So at this point, making the 4% safe harbor won't benefit them. But if they had been aware of or thought of this, or their advisors had, they would have been better off making the 4% safe harbor by the end of this year and not having to do the refunds for 2023. So that's something, make sure you don't overlook that if you run into a problem with your testing and you're trying to figure out whether making the safe harbor may enable those highly compensated to keep those contributions that they made in the plan. And then, of course, you've got your automatic enrollment notices and QDIA notices and a million other notices, it seems like these days, and make sure that those have all been distributed timely as well. Required amendments for 2024. Well, this is another good year in that we don't have any required amendments. When they're really going to hit, and if you've been paying attention at all to the IRS and the guidance they've been issued on Original Secure Act, Secure 2.0 Act, a whole bunch of interim things since then, they've pushed the amendment deadlines for all of that to the end of 2026. So 2026 is going to be a crazy year because in addition, that also includes the CARES Act and other acts that have occurred in this interim. And so you're going to be looking back at things that happened, multiple years ago, as long back as 2020, and having to amend plans by the end of 2026 for that. So I really do think that many clients and many administrators are going to start amending plans in 2025 so that everybody's not scrambling at the end of 2026 to get them all done. But we haven't really been able to do them yet, and really still aren't, because there's still quite a bit of guidance that the IRS needs to issue. So it's kind of good that they pushed this back to 2026 from that standpoint, but it's going to be difficult to encompass all of these things that happened over the prior, 6 or more years at the same time in 2026. So no required amendments for this year, but you still have the rule about discretionary amendments for things that were implemented in 2024. You must document that in an amendment by the end of 2024. The only exception to that, which is also a Secure Act change, is that you now have until your tax return filing deadline for 2024, if to adopt the amendment, that is, if you are increasing benefits. And so that rule really applies more than anything else to like money purchase pension plans or even defined benefit pension plans, because those are ones that would have fixed rates of contributions that previously had to be amended by the end of the year. Now they can be amended as late as the tax return filing deadline. If you've got a profit sharing plan or even a matching contribution that is discretionary, you always had until the tax return filing deadline to really declare your contribution and actually make it. The one piece that is a little uncertain here is the ability to potentially retroactively amend the plan if you miss the deadline. And so there are rules about self-correcting operational errors and certain plan document errors. And the big unknown right now is the IRS was directed by Congress to issue guidance within 2 years of the adoption of the Secure 2.0 Act. And the deadline would be December 31 of this year in order to issue that guidance. And we don't have it yet. I'm not really sure what happens when Congress directs the IRS to do something and they don't do it. So if they miss the December 31 deadline, I don't think there's any consequence, but I think they will certainly try to make that deadline because people are waiting on that guidance. And that, I have a whole lot of clients that are kind of in the boat of, oh, maybe they discovered something in the past that wasn't quite right. Can we self-correct this by now retroactively amending the plan to reflect the way it was actually operated? Probably, but that guidance is going to be really important. And so we should have that before the end of the year. And at that time, we'll certainly be reaching out to clients who we know have an issue like that we're waiting on this guidance, and other clients that find things like that, then, we'll know much more certainly whether we can do a retroactive amendment or whether really a voluntary correction program submission must be done, or an operational corrections need to be done. So nothing really that has to be done this year for amending your plan, but maybe things that you'll want to do once we have that guidance. Okay, another new thing that will come into play in 2025. So you know that if you have a 401k plan in 2024, you had to now begin to allow long-term part-time employees determined as 3 consecutive years with 500 hours or more. They've had to begin allowing them to contribute as of the first day of the 2024 plan year. Employer contributions aren't required for those participants, but they have to be given the ability to contribute. And if you have any participants like that, or I should say employees like that you didn't allow them to contribute, well, you need to correct that as soon as possible. And beginning January 1, 2025, if they have 2 consecutive plan years with 500 or more hours, you're going to have to enroll them and allow them to start contributing. So it's going to be important to do that as of 1/1/2025. And certainly if you haven't been complying yet for 2024, you need to do that as soon as possible, because you likely have some corrective contributions that'll have to be made for any of those participants that you miss. I said this last year at this time. I'll say it again. I think there's a lot of merit in looking at eliminating waiting periods for contributions entirely so that all employees are allowed to contribute immediately, even if you don't provide employer contributions for those employees, because it just simplifies the administration, and they've pretty much removed any of the downsides of allowing those participants in the plan as far as from top-heavy standpoint, as far as from ADP, ACP testing standpoint. It really doesn't hurt you to allow them to contribute immediately. So you may still want to think about that going forward. I want to very briefly just mention that the proposed fiduciary rules that have, I mean, it is just amazing how long these have been kicked around. They've been scheduled to become effective. It's been repealed and changing of administrations, court decisions. Once again, they were issued and scheduled to be effective now, and they've, it's going to significantly change the advice that advisors could give to participants in plans. And the big issue is IRAs. And once again, these rules are on hold because they've been challenged in court, and the court put a stay on the enforcement of this rule to determine whether the Department of Labor has the authority to regulate IRAs and to regulate one-time rollover advice. So not situations where clients have an existing relationship with their advisor, but just one-time rollover advice. The new rules would cover that, and that's what's being challenged. So the only thing that kind of remains in effect is the SEC has rules that advisors have to follow about giving advice in the best interest of the participants. So those are still in effect, but not the full-blown rules that would require a whole bunch of additional work for any advisor who is advising retirement plan participants. So maybe next year at this time, we'll actually have something in effect, but I wouldn't hold my breath. Another thing that is something I simply want to make you aware of if you're not already, but the FTC has proposed rules banning non-competes. There are some exceptions, but they would significantly restrict the number of individuals who could have a non-compete imposed on them. And that would have a very significant impact on our tax-exempt clients who have non-qualified deferred compensation plans, because it generally impacts when the deferred compensation becomes taxable. And so that's a very significant issue for them. Of course, it's a significant issue still for taxable entities, because it's just whether or not you can even impose those non-competes on your employees. But once again, a Texas court has recently issued a stay of enforcement. And the question is whether the FTC, the Federal Trade Commission, has authority to issue a ban on non-competes. So as of now, there is no restriction, no additional restrictions. There certainly are still restrictions on non-competes in certain states. But for example, Michigan does not have that. And so the rule is the same as it was before these rules were issued, until we get a decision from the courts on whether the FTC can impose this restriction. There certainly has been talk in Michigan and other states about potentially banning non-competes, or at least restricting them to certain very highly paid individuals. And it's possible that something like that could come into effect in the future. But as of now, you don't need to worry about it. One thing you should pay attention to and potentially worry about, if you, especially the larger the plan is these lawsuits regarding the use of forfeitures in retirement plans. So if you haven't heard about this, there are more and more lawsuits being filed every day. The plaintiffs' lawyers, I think, felt like maybe they had exhausted a lot of at least challenging the big employers on the excessive fee issue. So now they're challenging them on plans that give discretion to the employer to determine whether they're going to use forfeitures to pay plan expenses or reduce employer contributions. And the logic is that once the money's in the plan, the employer and the plan has that discretion needs to be exercised in the best interest of the participants, which would generally be to reduce their expenses rather than reducing the employer contribution, which benefits the employer. So the way to eliminate the risk going forward is to specify how the forfeitures are used. And the easiest way to do that is just to specify that they will be used to reduce the employer contributions. And if there's no employer contribution made, then they'll be used to pay plan expenses. That kind of eliminates the issue, always works out in the best interest of the employer. And the employer can always still choose to pay plan expenses separately out of its own money, which would be the same as it was doing if it used forfeitures to do that and didn't reduce its employer contribution. So this is simply a plan document drafting issue that can resolve this problem. But the larger the plan is, the more important that this be done sooner rather than waiting until the next restatement, because the plaintiff's lawyers are, as they always do, going after the biggest plans first. So if you're a real small plan, I don't think anybody's going to be coming after you by the time you can fix this in your next restatement, maybe in 2026. But if you're a bigger plan, then I think it makes sense just to amend it now to at least eliminate this risk going forward. They still could sue you for the prior years, but that's pretty unlikely. The interesting thing about this is that the IRS has permitted forfeitures to be used to pay plan expenses or reduce employer contributions forever, as long as I'm aware of. And so now it's interesting that the plaintiff's lawyers have been successful with this, despite the fact that the IRS has approved plans with this language in there. But once again, IRS is only dealing with the qualification of the plan, not really the rights of the participants. Though the Department of Labor, who generally does protect participant interests, has never said anything either. So that's why a lot of people were caught by surprise on this. Okay, the next thing is one of the few parts of the Secure Act 2.0 that becomes effective January 1, 2025. As you know, there were things that were effective immediately when it passed, a few things that became effective January 1, 2024. There's quite a few more that become effective in 26 or 27, but this one is 2025, and it's the new catch-up limits that are increasing, assuming that your plan chooses to offer them. Once again, it's not mandatory, but if you're going to allow them, you certainly need to make the participants aware and certainly make sure your record keeper can handle these increased contributions. So I put here the projected limits for 2025. We don't have certainty on that yet. We will know sometime in October what the actual numbers are, but it's likely that the normal contribution amount will go to $24,000. It's possible it could be within $500 different than that, but we think that's what it'll be. So we've got the before 50 limit is 24,000. After 50, the normal catch-up will probably go to 8,000. It's currently 7,500. So you'd have 32,000 that you could contribute in 2025 if you're 50 or over. Now there's this new additional one. If you're between ages 60 and 63, you get 150% of the catch-up. And so that would go to basically be $12,000 instead of $8,000. So your limit would be $36,000. And remember, you have to be those ages at the end of the year. So next year, if you turn age 63, which just happens to be the year I turned 63, I will have 1 year of getting this extra $4,000, because the next year I'll still be 63, but by the end of the year I'll be 64. I will not be eligible for this, because 64 and older, you're back down to the $8,000. So This is something, it's nice, get a little bit more. It's certainly not going to make a huge difference to people's ability to retire. But most clients, I think, are going to want to offer this because certainly others will be, and people will be saying, why can't we do it if others are doing it? Keep in mind that the mandatory Roth catch-up deferral contributions, I didn't include that word catch-up there in the slide, for participants with compensation in excess of $145,000 becomes effective 1/1/26. So basically those people will have 1 year of getting the extra catch-up contribution if they're between 60 and 63 that they can do still on a pre-tax basis, and beginning in 2026 they will still be able to make these additional catch-up contributions, but all catch-up contributions are scheduled to be have to be Roth for those participants making $145,000 or more starting in 2026. Other changes to consider for 2025, though most of these you can do for 2024 if you want. Federally declared disaster distributions for in-service from plans up to $22,000. Terminal illness distributions can now be made, and there isn't a cap on that. Distributions in the event of domestic abuse of up to $10,000 or 1/2 of the vested account balance. And then the personal emergency expense accounts, that's kind of a separate account that you have to establish. The other three are just out of your regular accounts of up to $1,000 a year. The nice thing about all of these is that the 10% excise tax doesn't apply to these types of distributions. I really wish that Congress would just simplify this whole thing and just allow, say, up to $10,000 in-service distributions for any reason, and maybe just a one-time thing with no excise tax, rather than complicating everything with all these different types of distributions that you have to make sure you're complying with. But these are all optional, so you don't have to allow them now or ever, but maybe in 2025 you want to consider doing that as well. Okay, the last thing I'm going to cover, and then I will try to address the questions that have come in. There are a couple of them. Is the new private letter ruling that I do think clients will want to be aware of. And this was issued. So once again, a private letter ruling is something that an individual company goes to the IRS and says, we would like to do this. And the IRS either says, yeah, we'll approve that, or no, we won't. But it's kind of like a determination letter for a qualified plan. It applies only to that client that requested it. But I do think that this was not earth-shattering or was not radically different than what we would have thought. So I would not be uncomfortable if other clients went ahead and did this kind of thing without getting their own private letter ruling. This private letter ruling has some costs and some times involved in getting it. But what this ruling said was that it would allow participants to make an election before the beginning of each plan year. So kind of be like open enrollment for health insurance, and you would have 4 choices. So let's say that the employer decided we're going to give $5,000 to each participant to use how that participant wants to, but it's not a 401k election because one of the choices is not that they take this money as cash that's taxable now. Their choices are limited to things that are tax-free or tax-deferred benefits. So that's why the IRS allowed this. And so the choices that were approved in this private letter ruling were, 1, an employer retirement plan contribution. So let's say employer says, here's $5,000, use it how you want. One of them can be an employer non-elective retirement contribution. Even though it kind of is elective here, they're saying it would be treated as a regular profit-sharing contribution, not taxable to the participant. Another one is an HSA contribution. Now, the HSA contribution, of course, has limits, so a single individual wouldn't be able to get the whole $5,000 in there. A married individual would, but they as much as possible in the HSA and then have the rest go into the employer retirement plan, for example. Third one is the repayment of student loans to an educational assistance program. Now, the interesting thing is right now, the repayment of student loans is scheduled to expire at the end of 2025. So there might only be 1 year that it could be used for that. I think a lot of people are hoping that will get extended, but if it doesn't, there'd still be the ability to pay for educational assistant expenses under this program, but just not repayment of loans that were incurred for prior educational expenses. So that one we'll have to continue to watch. And then the last option would be a contribution to an HRA, health reimbursement account. So I like this because I've never been a big fan of the new rule that allows you to make matching contributions to your retirement plan for people that repay student loans. Or, of course, you're going to make your matching contribution if they make contributions to the plan, because it leaves out those people who really can't afford to make contributions to the plan and didn't have student loans. So certainly some very lower paid people get harmed by that. This arrangement, they're not harmed because they can always have it go in as a retirement plan contribution. If they need it for repaying student loans, if you need it for health insurance, and of course your HSA contribution is generally the best place for people to put it because the money goes in tax-free and comes out tax-free if it's used for health insurance. So I view this as a better alternative than just providing that you will match people's accounts if they repay their student loan, even if they don't contribute to the 401k plan. A couple of things that you need to keep in mind with this, though, is there still is non-discrimination testing on the contribution to the retirement plan for any money that goes in. And I think that can be dealt with fairly easily, especially if you treat highly compensated employees a little differently than this. I think this is much more likely to be beneficial to a broad group of employees, so it's unlikely to end up being discriminatory. You will have to have proper documentation of it, and then you do have to pay attention to those contribution limits, as I indicated regarding the retirement plan. You're probably going to be fine generally, but the HSA and the repayment of student loans have specific limits in them. Okay. Quickly, I'll try to look at the questions here and see if we can answer those. If not, we'll try to do that at November 20th. But so one question is about the forfeitures, the use of them actually winning. Do we think that they will actually win? Well, I think there's a decent chance that at least some of them may win because we all know that forum shopping is alive and well in this country, where people file lawsuits in certain courts because they know they're either more favorable to the employers or the employee. And so it's certainly possible and almost likely that at least one or more of them will win. But the bigger issue is probably you just don't want to be on the other end of a lawsuit like that because the expense that you'll pay defending it, and it's highly unlikely that you would get attorney's fees for having to defend that suit. So even if you end up winning, it will likely cost you much more than you would want. So I highly recommend that you amend your plan to eliminate that problem. Next question was how does specifying the forfeitures will be used only to reduce employer contributions protect against plaintiff's claims that the only proper use of forfeitures is to reduce plan expenses? So there isn't anything in ERISA that requires you to use forfeitures to reduce plan expenses. The issue is whether, because the plan provides discretion to the employer, that then once the money's in the plan, and generally there is a prohibition against using exercising discretion that is not in the best interest of the participants. So if we take the discretion out of the plan and just say that the forfeitures have to be used to reduce employer contributions, it's not a violation of ERISA or the Internal Revenue Code. So that's why it is so simple to eliminate the problem. Another question was, how do they define age for catch-up contributions? Is it age 60 anytime in the plan year? And I think I answered that, but yes, you look at what it's kind of like the age 50. You become eligible for catch-up contributions if you will attain age 50 by the end of the year. And here it's you will be eligible for the additional catch-up if you attain age 60 to 63 during the year. But if you attain age 64 during that year, you're not eligible. So that's how that one will work. Last question are, what are thoughts on portability service network and participation in this? I don't know that I have a lot of thoughts on it yet. I think we've been reviewing some of these, and we do have some concerns about how they're being handled. So I guess I would say at this point, my best feeling is I think I would still wait on getting into that. That's where basically you're missing participants, you're lost participants, or even just terminated participants. You're going to start sending the money through these so that you don't have to deal with the eventually lost participants and all that. And I think this is something that can be good down the road, but there's still some kinks that need to be worked out, and the agreements that we've seen are not don't have exactly the language we would like in them. So I definitely won't say no, but I think like everything in the employee benefits world, you're rarely better off to be the first one to jump on board because things haven't all been worked out. But kind of like this private letter ruling that now has been issued, and somebody has kind of gone through some of that, it might be something for others to start considering. Those are all the questions I have. Thank you for your time, and remember to submit those questions for our November 20th webinar, and I hope you all have a great rest of the day.